Yes, Council.
Good evening, Council.
Good afternoon and good evening to everybody who has joined us. Sorry, I'm told there's something wrong with my sound. Good morning, good afternoon, and good evening to everybody who has joined us from wherever you have joined us from. It is our honor and privilege to be having for a second week in a row Mr. Maxim Mutawingwa, a senior advocate by any measure, who has come to discuss this topic with us, deadlines for the dead, understanding the expiry of letters of administration. We are, first of all, very happy to have you all here. My name is Ellison Karuhanga, otherwise known as the lawyer's lawyer. Honored and privileged to be here with you all. I'm here with Alfred Muyaka. I think Mercy will be joining us shortly. And we are really going back on the conversation we had last week. For those of you who joined us last week, in 2 days' time, many people's letters of administration in this country will be expiring. Letters of administration and grant of probate are things we were told last week that they are, when you die, the law recognizes you as having died in only two ways. You die with or without a will. You die testate or intestate. And we were told about the different processes. And for those of you who are not conversant with the legal processes, we are here for you. We shall help you, walk you through these processes as simply as possible. As you all know, this is a lawyer's space. We try as much as possible to provide as much information to the legal fraternity and to our colleagues at the bar, and to enrich the discussion of law in the Republic of Uganda. So allow me first of all to welcome Mr. Mutawingwa. Mr. Mutawingwa is a senior advocate. He has been in practice, he told us, since 1998. He has been in the courtrooms every single day. At one time, he was well known for representing the mighty Red Pepper. He never got any suits for Mr. Haina, but I think other people may have had a suit here or there. But more than that, he has been a very prolific and prominent advocate in the courts of this country. And on this particular subject of family law, he is known as the Koja of the family law specimen in the country, this family law group. So there's no better person to answer these questions. Now, the purpose of why we have repeated this conversation, many of you sent us questions, and we felt, and many people told us that it would be important to have this conversation again as the letters of administration start to expire. And the idea is that we will have this conversation again. And today, more than last time, we shall try as much as possible to include as many of your questions as possible. We are live on X, on YouTube, and on TikTok. And there are people here who do these things. And so we're live on all those platforms. And as much as possible, we want to bring the information to you. So otherwise, thank you so much for joining us from wherever you're joining us from. Welcome to this Nobody Can Stop Reggae discussions. And over to you, Mr. Mutabingwa. How are you, sir? And we hope you've had a wonderful week.
I'm fine, sir. Thank you very much. Thank you very much, Edison and team. And I'm very honored and privileged for being invited again to talk about this important topic which has generated a lot of debate. Thank you very much, Edison and team. And I'm very privileged. I'm very privileged and honored to be called back to talk about this important topic, which has generated a lot of debate in the population. After our discussion last week, there is a lot of debate which has been generated in the population, in the whole country. Actually, people are calling me from very far as Kanungu, as far as Guru, as far as Arua. Everybody is calling me because of that discussion. And it is because this law of succession touches everybody. It touches everybody. The estate of the estate of the deceased touches everybody. There's no.
If I can hear you clearly.
Yes.
Maybe let's just give it a minute and try and fix that. I don't know if you give me a thumbs up, but I think we were missing a lot of what you said, Mr. Mutabingwa. Let me just make sure that we are all on. I hope, I don't know if you could all hear Mr. Mutabingwa, but in case you couldn't, we are, in case you couldn't, please, trying to. Are we on?
You seem to be muted.
Okay, I hope you can all hear me. Can you hear me?
Wait, another link. This where I saw that there were connection issues. Actually, I saw the stuff that's when I started asking you whether the space is on. So just create a new link and you can share faster.
It's okay, it's okay.
Wi-Fi the problem? But he's a listener. Speaker. Mine is slow. Good morning, good afternoon, and good evening to everybody who has joined us from wherever you've joined us. It is before, but like we always say, when Elon Musk hosted Donald Trump on Twitter, the thing crashed. So I think Mr. Mutabingwa is like Donald Trump. I don't know, or maybe Elon Musk. But again, welcome to everybody who has joined us. Sorry for the technical glitches we are having. We are discussing the topic deadlines for the dead, understanding the expiry of letters of administration. And last week we had this conversation with Mr. Maxim Mutabingwa. Mr. Maxim Mutabingwa is a senior advocate of the Courts of Judicature of Uganda. He has practiced law all over the country. He has a deep and proper understanding of the law. He has a feel for it. We don't know where he was legally formed, but wherever he was formed, he has come out to be a powerful legal advocate and very knowledgeable on the subject that is before us today. Just as a take back, we are looking at the issue of expiry of letters of administration. And section, I think it is now section, it is now section, I think, 341 of the Succession Act, of the Succession Amendment Act, which provides that a grant of probate or letters of administration issued by a court of competent jurisdiction before the coming into force of this act shall remain valid for a period of 3 years after the coming into force of this act. The act came into force on the 31st of May 2022, and 3 years have come, and the 3 years are going in 2 days. And so we have with us someone to take us through this subject, to hold our hands and help us understand them. We've received many questions from many people, and we decided to have this conversation again. Today we want to mainly focus on your questions and not ours. Please feel free to ask questions, send them in the chat. But for now, allow me to first and foremost welcome Mr. Mutabingwa. Sorry for the technical glitch that we had. You're most welcome to our reggae spaces, and as you know, sir, nobody can stop reggae, but maybe if you could just say hello to everybody and your opening remarks.
Good evening, listeners and viewers, and the Edison and team. Thank you very much for inviting me back to this forum. I'm very honored and humbled to have been called back to talk about this important topic. After our discussion last week, I got so many calls from all over the country. Almost everybody was calling me to ask me about this important topic of succession. And as you well know, succession touches almost everybody. So every citizen, everybody is concerned, especially the lawyers and non-lawyers alike. Everybody is interested in this topic. So I'm very glad to be invited back, Edison and team. Thank you very much.
Okay, thank you. I think maybe we'll hit it off immediately. We'll hit it off immediately. And one of the questions which has really come up is still what I would call a definition question. You could just help us. I know I've said it, but if you could just take us again very briefly through an overview of the law of succession. And the primary question is, what we are really asking is, when do letters of administration expire? And after they expire, what happens next? Over to you, Mr. Mutabingwa.
Thank you very much. Last week we talked about probate and letters of administration. But now I'm asked to explain about letters of administration and when they will expire.
And probate.
And probate. Letters of administration and probate, and when they will expire. Letters of administration and probate are two different categories. We are talking about two different categories. One, we are talking about letters of administration and probate, which were granted by court. before the coming into force of the Succession Amendment Act. And the Succession Amendment Act came into force on the 31st day of May 2022. And those grants are provided for in the Succession Amendment Act under Section 341. And those grants which were made before the 31st day of May 2022, according to the Amendment Act, Section 341, subsection 2, and subsection 3, all those grants are going to expire on the 31st day of May 2025. Also, when the 31st day of May, is it Monday or it is Sunday? So they are expiring on Saturday. Then we have another category of letters of administration which were granted after the coming into force of this Succession Amendment Act, which were granted after the 31st day of May 2022. Those ones have a lifespan of only 2 years. 2 years only. So the other ones have a lifespan of 3 years. Then these ones which were granted after the coming into force of this act have only a lifespan of 2 years. So these ones now, they will expire on the 31st day of May 2025. So what happens when the letters of administration expires? Everybody is asking me about this question. What happens when these letters expire? It's becoming a very big issue. Everybody is worried. Actually, there is a stampede now.
Yes.
Now, does court have power to renew these letters of administration? Everybody is asking himself about that one. Actually, I took trouble and even I moved to family court and asked, you people, what is going to happen? Are you going to renew? Are you going to extend? But my personal view, according to me, these letters, when they expire, this is my personal view. When they expire, I don't think court has any authority to extend them or to renew them. They have already died. Now you see, under Section 341, subsection 4, you see what it says. This is about extension, about these grants. Actually, there is a law here. A grant of probate or letters of administration referred to in subsection 2 and 3 may, on application to court by the executor or administrator of an estate, be extended for a reasonable period determined by court. So they can be extended. But which grants can be extended? In my opinion, the grants which can be extended are those ones which have not expired. You cannot extend or renew a grant which has expired because it is no longer a grant. So if you want your grant to be renewed, you must apply for extension before expiry thereof, before the 31st of May 2025. So it means you have only tomorrow and Friday to apply for extension of these grants. Otherwise, the court does not have any authority to renew them or to extend them. And then it means you have to go back to apply for letters of administration afresh, or any person can go and apply for letters of administration afresh. That is my view. But when I went to family court and I asked the judicial officers, they said, no, we shall have power to renew. Not to extend, but can you renew the grant of letters of administration which has expired? In my opinion, no. So we have only 2 days to apply for extension of the life of these grants of letters of administration. Otherwise, we have to go back to the whole process of applying for a fresh grant, either by the administrator whose grant has expired, or a fresh person can apply for a fresh grant.
Okay.
That is my view.
Okay, and that view is very interesting, but there are, I don't know, there's even decisions, I think, of the court. Someone has told us of a decision of the court in Mbarara, the High Court in Mbarara, that rejected an application before and said you must only apply after they have expired. So the question is there a uniform interpretation of the law on this thing, or is the law going to... Is the law still unclear and undefined?
The law is very unclear, There is no uniformity because each judicial officer is interpreting the law in his or her own way. Because I heard there is somebody who applied even for extension of the time of these letters of administration, but the judicial officer said no, the grant has not expired. That you cannot apply for extension of a grant which has not expired. That is the understanding of a legal officer. That if the letters have not expired, how do you apply for renewal, for extension of time? But in my opinion, you apply for extension when the grant still has life. So if it is dead, you cannot apply for extension. Now I give you an example. We are advocates. Every year we apply for renewal of our practicing certificate. You understand?
Yes.
So if my PC has expired, then I apply for renewal, but I go through the same procedure.
Yes.
Yes.
There must be approval of chambers. You must file your NSSF for clearance certificate.
Yes.
You must do a BC.
Yes.
So actually, you get a new one. Like now we have got the ones of 2025. You cannot refer to the one of 2024. So you see, it is no longer operative. It is no longer in operation. It has died. So this is what is going to happen to the letters of administration. Regarding, maybe court will use it in inherent powers. I don't know from where to renew. In my opinion, court does not have any authority to renew these grants, which will expire on 31st day of May 2025. That is my opinion, and which I think is right.
Saturday is the end of the dead will die properly on Saturday.
They die on Saturday, so everybody over there, you still have 2 days. You still have tomorrow. You still have to even on a Friday to apply for extension of these grants of letters of administration. Otherwise, on Saturday, you are no longer an administrator. Another person is going to apply for a grant, and then you will be granted. You are no longer an administrator after Friday.
And when they are making this application, there's this thing called an inventory that you spoke about last week.
Yes.
There are some people who are saying, why do I have to do any of that? Why should I allow? I think there was a question on TikTok where someone was saying, I don't need any of those. For us, we are going to organize our things away from that system. So tell us, first of all, why do they need to apply for these letters? What's the legal effect of if it expires and you leave it alone and nobody's administering the estate? What is the legal effect? And then for those who want to apply, a lot of people have been holding property for decades as administrators. There's no problem with the beneficiaries. They're handling the estates together. When the property, when the grant expires, before Saturday, if this person has not filed an inventory, what is the inventory? Why should it be filed? And can you apply for these extensions without the inventory? I think that's a question I'm seeing coming up.
Thank you very much, Edison. Last week we talked about an inventory. An inventory, when somebody has become an administrator or executor of the will, he compiles a list of the properties of the deceased. List of the properties, list of debts, list of credits of the deceased. He compiles them into a list, and he files that list in court within 6 months. It is a requirement of the law. That is what we call an inventory. Then an account. He compiles the list of the properties of the deceased person in a list, and how he has distributed those properties to the beneficiaries. Actually, I have seen the format of the inventory. Even the beneficiaries sign against the properties they have taken in the final accounts, and he files that document in court. That is what we call the final account. It is a requirement of the law. You have to file an inventory within 6 months from the date of the grant. Then it is a requirement of the law to file the final accounts within 1 year after the issuance of the grant. It is a requirement of the law. So you are saying that to extend, do you need the inventory? Do you need the final accounts, you see, if you didn't file those documents within the prescribed time, you first have to file them, but you must apply for extension of time also. You must file an application for extension of time to file an inventory. Actually, now what we do, like what I have been doing, I make an omnibus application. I made an application today, and I'm going to file it tomorrow on behalf of my client, because he came with a lot of stampede. So I have made an omnibus application. One, an application to extend the lifespan of the grant of letters of administration. Then I also applied for extension of time for filing an inventory. And also I applied for extension of time for filing the final accounts. And I put them in one application, so I'm filing that omnibus application, and it serves the purpose. Because you cannot do anything. You cannot administer the asset of the deceased if you have not filed an inventory. First of all, an inventory. You cannot. They cannot allow you to do anything. You have first to file an inventory. If even these people who have been having the letters of administration which have not expired, even to get a certified copy of the grant of the letters of administration from court, they ask you, have we filed an inventory? Did you file an inventory? No. First apply for extension of time within which to file an inventory. Then when that application is had and you are granted time, then you first file an inventory, and then you can go ahead. Like now, I have a client. He had not filed an inventory, and he came to my office, and then we applied for extension of time to file an inventory. Then the judge said, I will send my decision on what? Online. So the decision was sent online, but my client did not see it. And he was given only 2 weeks to file an inventory. So by the time he saw the ruling, the 2 weeks had expired. So now I'm again applying for extension of time. Because he was given only a period of 2 weeks to file an inventory. But by the time he saw the ruling online, the 2 weeks had expired. So now I'm repeating the application, but I'm making an omnibus application also, extension of time to extend the grant. Extension of time to file an inventory. Even I have the inventory and I have the final accounts, but I cannot file them because there's no extension of time. So you have first comply with the law and apply for extension of time to file an inventory. And now I'm repeating it because the 2 weeks which was granted have already expired. So we have to comply with the law. You cannot administer the asset of the deceased if you don't follow the law. And the law, the first step after getting the grant is to file an inventory. Then the second one is to file the final accounts in 1 year. And then that final accounts is also followed by an affidavit. You file the final accounts in court, followed by verified. They say verified by an affidavit. That's what the section of the law says. And then when the court receives that affidavit, it sends 2 copies to the Administrator General. And then that is when the estate is wound up. So we have no shortcut.
Okay. Thank you, Mr. Max. I have one comment from here. Our man from Ntungam, the only lawyer who doesn't accept bribes. As if he has the other. Even there are very many lawyers who don't accept. You don't know lawyer. Okay. Now, the first question is, we have all agreed that as expiring on 31st May. So we are talking of applying. So this one is asking, what's the process for renewal of letters of administration and the costs involved? How do you apply? Is it by way of a letter? What do we need to attach? How much is involved? And how long does it take? I think this is Madam Hope is asking the process of renewal of letters of administration. How do you apply? The documents we need to have, even the costs involved.
How do you apply for renewal of letters of administration?
Yes.
By renewal of letters of administration, I mean those letters of administration, a grant which still has life,
yes,
as I have already explained. So what do we do to renew? According to the law, there is this general, all applications to court, they must be made by notes of motion. Yes. So you don't make a letter. There is a legal document called notes of motion. So we make a notes of motion, then supported by an affidavit. Yes. But if you look at section 54 of the Amendment Act, Section 54 is very clear and very strict. You see now, the framers of this law wanted to protect the beneficiaries because the administrators have been cheating the beneficiaries. Actually, last week, I made a comment here which generated a lot of comments and debate when I said that the lawyers were cheating the administrators and the beneficiaries, and I was very right. Lawyers are fleecing beneficiaries because, like I told you, applying for a grant of letters of administration, it is not a lot of money. Talk about 1 million shillings, 2 million shillings, but the lawyers have been asking for payment in kind, and it takes 50 acres. That is a lot of money because he capitalizes on the ignorance of the what? Of the client who doesn't know the law. Because like I have seen many clients, they think that going to court and getting the letters of administration is a big deal. It is a small thing. Actually, even according to the law, the remuneration and taxation of costs rules, even the fees are provided there. But the lawyers don't want to show that one. So they go ahead and they charge exorbitant sums of money and they cheat the beneficiaries of their estate. And somebody has died, has left the orphans, you cheat them, then you see, go and he will punish you. So there I was right. Whoever has been asking me, especially the advocates, have been attacking me, that don't you get money in kind? I have never cheated any beneficiary, I have never cheated anybody, I have never cheated any administrator. Then back to the question.
Yeah.
Renewal of letters of administration, what does it take? Everybody should know this. Somebody wants to apply for extension of time. What does it take?
Apply for renewal.
The framers of this law wanted to protect the beneficiaries, and they made the law very stringent. Section 40. So what I want to say here is that, one, you must make an application by way of notice of motion. Then you make an affidavit supporting it.
Yes.
In addition to that, now hear this, you must get consent of all the beneficiaries. All the beneficiaries must consent to your application of extension of time. And there is a problem which has arisen here now. Some beneficiaries are staying in Uganda, some beneficiaries are staying outside Uganda. But the law says all beneficiaries. So you have to hunt down all the beneficiaries and they have to consent to your application. And I have seen in courts what happens. All the beneficiaries have to be there. There's no out. Even these ones who are outside the country, they put them online. They use Zoom and other methods, but they must put them online. Then another requirement, you must prove to court that it is in the interest of all the beneficiaries to extend the period. You must prove that it is in the interest of all the beneficiaries. If you don't prove that one, extension is not going to be granted to you. Then you must have also have complied with the provisions of this act or any condition of which the probate was granted. You must have complied with all those. This subsection 3 is consent of all the beneficiaries. So you can see now it is very stringent. You just don't walk to court and then you apply for extension and it is granted to you. No. There are conditions now, yes, which conditions are very stringent. Like imagine how do you get all the beneficiaries? Like today I was applying for extension. The beneficiaries are 7, but 2 are outside of the country. And we are left with only 2 days. So what do we do? So that I don't know what we are going to do. But I have said maybe they can bring them by email. And we are expecting them tomorrow. But they have to consent. And you have to attach the consent. Your application has to be followed by to be accompanied by the consent of the beneficiaries. So this law, the framers of this law wanted to protect the interest of the beneficiaries. And now everything you do as an administrator, the beneficiaries have to consent. So that is what it takes to apply for extension of the grant of letters of administration.
Yes, maybe just to add on that.
Yes.
If all the beneficiaries are consenting, and then you are saying, initially you mentioned of having them as respondents.
Yes, yes.
So they give you the consent before applying, and even they come in court as respondents.
Yes, yes. Because one, you attach the consent of the beneficiaries.
Yes.
And then, of course, they are also respondents to the application. They are also respondents to the application.
Yes.
Of course, as parties, they are required to be in court. And I have seen judicial officers are very strict. They want all the beneficiaries so that they ascertain whether they have consented or not.
Yeah.
Yes.
So there was this argument that if they are respondents to the application, instead of having their consent attached to the application, since they are going to be, since they are respondents, they are supposed to maybe fair enough that in reply to the application. So what if they respond in that reply to the application, more or less consenting to the grant? Would that suffice instead of having the consent attached to the application?
What I have seen, what courts do, the question you're asking is maybe form and content. The most important thing is not the form, but the content.
Yes.
What the courts require is that the beneficiaries appear in court, and even they are identified in court, they are seen in court, and even they are asked. Okay. So this form of saying whether an affidavit in reply, that one is not material. The most important thing, before you are granted the application, before the application is heard, have the beneficiaries consented. The judicial officer has to ascertain that they have consented.
All right. Then another question I received was from Rita. It says, we are joined as administration, we were granted to 4 individuals in 2000, and 12 that the administrators have since passed away. So what remedies are available to the surviving administrators? So I hope you get it.
Actually, I have been asked this question by many people. So, if letters of administration or probate is granted to several individuals, yes. And now, before the winding up, completion of the process of administering the state, then one of them or some of them die, but others remain. What happens? So the law has an answer. The law has an answer in the section 269 of the Succession Act, and it states, section 269 states, hear this: upon the death of one or more of several executors or executrixes or administrators or administratrices. I have never heard of this word, administratrices. I am hearing because now you see this creation of he, she, him, her. You see now because of equality of men and women, but because this word is new to me. All the powers of the office become vested in the survivors or survivor. So the law is very clear. But what happens? What the courts do is not what is stated in the law. Because like in family division now, when you are several administrators and one of them dies, if you go back to court and show them that one administrator has died, for them, they revoke your grant. That's what I have seen. They revoke your grant. They say now, but when you are granted the letters of administration, why the administrators were several or many, other administrators were catering for some groups. You find somebody has died, he had about 2, 3 wives or 4. And they had chosen an administrator from each family, each wife. So like one of them dies. So he's going to represent now the other family. That's what the courts are saying. But the law is very clear. The surviving administrator should continue and administer the estate. And what we have been doing, when an administrator dies, then you apply for a certificate of death. You get a certificate of death. Then whatever the surviving administrator does, he attaches the certificate of death to show that the other administrators have died. And then even in lands, they have been transferring the what. But courts now, they don't follow this law. The law is there, but courts are not following it. So if you have a joint grant and some administrators die, the courts now require you, they first revoke that one. and then they want to issue another grant now. They call the beneficiaries now back. You don't go back to Administrator General. No, they call the beneficiaries now to court.
Yes.
And then they ask them, do you want him to continue administering the estate alone? If some beneficiaries say no, then they choose other administrators and add them on to the grant, and they give you a fresh grant with other administrators, but which is contrary to the law, because the law is very clear. So what is done in practice is not what is in the law, but the law is very clear as I have read it.
So simply it loses, not lose her question. So what is supposed to do? Should do apply for revocation or for renewal now? Because we have lost somehow here on that question.
I don't get the question.
Okay, the question was, there were 4 people.
Yes, 4 people.
Two have died.
Yes.
So 2 are remaining.
Yes.
And now they think that is expiring on 31st.
Yes.
So they are now apply for revocation. Their revocation, or they apply for their
according to the law, if some administrators have died, the surviving administrators are supposed to apply for extension, but they attach the certificate of death of the deceased administrators. That is the correct procedure. But not to apply for revocation, no. Because how can I apply for revocation of the grant, which is granted to me? I'm capable, and the law supports me. So why do I want the other administrators to be added on to me?
Over applying for amendment. What about the amendment?
No, but the law does not talk of amendment.
Okay.
You see me, I'm a person of the law, and the law is very clear. Even if it is one surviving administrator, they should let him do the work and complete the administration of the state.
Okay. I think we have.
But I'm warning, that is not what is happening at the family court. No, they don't follow this law.
They don't follow this law.
They don't follow it.
Okay, so I think maybe we'll take one question from Norbert before we go back to our other questions. Norbert, if you could just ask one question in under 1 minute. I don't know if Norbert, you're asking a question.
I've muted him. But you can proceed.
Okay, Norbert. Okay, as Norbert is organizing himself, I think there was a question about where the grant of letters of administrations are set to expire on Saturday, and during the course of administering the estate, new properties were discovered. So maybe the inventory was incomplete or something like that. So the person is asking, in that case, what should happen in respect of the newly discovered assets?
So newly discovered properties, if the properties have been discovered during the subsistence of the grant of letters of administration, the administrator has a right of administering that estate, because when somebody is given a grant, his work is to trace the properties of the deceased and administer them. So if the grant is still subsisting and you have come across other properties, then the grant is still subsisting, then you can file an inventory and you also administer them. You apply for, if the time of filing an inventory has expired, in my opinion, you apply for extension of time, because you have a justifier, because you have come across other properties of the deceased and you are the administrator. Then you can administer them before the expire of the grant.
Yes.
But if the grant has expired, then it means you need a fresh grant of the letters of administration as an administered administered part of the state. You apply for a fresh grant. If the administrator had wound up,
yes.
You apply for a fresh grant to administer these properties which you have discovered after the expiry of the grant. But if the grant is still subsisting, then you can administer it.
I think maybe to add to this question, the question, because he was imagining when I was applying for letters of administration, my petition had 3 properties.
Yes.
So it means court gave me powers to go and administer those 3 properties.
Yes.
So now I have a fourth property.
Yes.
So that's where he was having the issue. Should I go back to court to give powers to administer the fourth property? Should I use the same grant to administer also the fourth property? What should I do? You get? I hope you get the question.
You have got letters of administration.
Yes.
Then maybe in the application you listed 3 properties.
Yes.
Then after the grant, you trace the properties.
Yes.
You make an inventory and you file it in court. So have you divided the estate or you have not?
No, not yet.
Yes. So if you are still within time,
yes.
In my opinion, you can include it in the final accounts because you have come across it. You are an administrator, you have the power, and the grant is still valid. But the problem comes after the grant has expired. There you need a fresh grant to administer the estate, the part of the estate which was not administered. Yes, I think it is very clear there.
Okay.
Because once you have been granted letters of administration, you have power over all the properties of the estate of the deceased, which you knew, or whichever property you come across. Yes, it doesn't mean that you administer only the properties which you included in the petition. No, because those are the properties you knew. But the work of the administrator is to trace all the properties. So if you come across them during it is your duty. If you come across them during your duty, then you administer them, but within the time of your grant. If the grant has expired, then you have to apply for a fresh grant to administer that and administer the part of the estate.
Okay, please, for all of, if you're just joining us, welcome to our discussion today on Reggae Spaces. We are joined by Mr. Maxim Mutabingwa, a senior advocate, discussing deadlines for the dead. What happens to the estates after the letters of administration expire? Do they remain, do our dead remain dead, and do the estates now die with them? Those are some of the questions that are being asked. Please, if you have a question, feel free to type it in here. If you wish to speak, please ask for the microphone. We'll be giving you just under a minute to ask your question. But we are very happy and privileged to have you here. We are discussing a topic that touches on the lives and deaths of many people on the estates around the country, and we are honored and privileged that you've joined us. One of the questions, Maxim, that people are asking is I think there's a lot of concern about this expiry, and some people are asking. I've seen questions coming from TikTok where someone is asking, do the courts have this time? Will they have time for anything else? And another person is asking, how long does it take to actually get letters of administration? If we all have to apply right now, and if we have an expiry, will we be able to get these letters quickly enough to go back to the administering of our estates, or is there a risk that time is going to be taken? Of course, I know that's a question we should probably throw to the judiciary, but as an officer of court and a senior member of the bar, and then other people also asking, I think a third question I'm seeing here is, there are questions about what are small estates and how are small estates managed? Where do you go to the high court? Where do you go to a court lower than the high court? I think those are some of the questions coming through for us. But please, if you wish to ask anything, feel free to type it in the chat box. Otherwise, feel free to ask for the microphone.
Thank you very much, Edson. Now, this question of expiry must generate a lot of concern, and it is generating a lot of concern, and rightly so. Because after expiry of the letters of administration, what happens? There is going to be a lot of commotion and stampede, and it is already there. So, to ask, do our courts have the capacity to handle all these matters? Like I told you, I have already told you. Like the case backlog in our courts are burdened with cases. We have a lot of cases, even at family division. Even without these other applications which are coming, the family court has already a big backlog of cases. And now, to handle all these applications for extension and renewal, it is going to take a lot of time. And the judicial officers we have, I don't think they are going to manage. because they are going to be overburdened. The applications are so many. Like this week, I think myself, I have filed like 5. Now imagine all the farms in Kampala, they are filing these applications. So even it is going to, you will find that extensions, so to get these extensions, it will be taking like 3 years, 4 years to reach your application. Because there are so many applications. Now, how many cases are in court? Because the courts are not handling only these cases of extension. Because there are divorce cases, there are other cases, there is separations. There are land matters in family division. Maybe the division of the estate has gone bad and it has resulted in 2 suits. There are so many suits. So now, if you add all these applications for extension, even if they say now we don't want people to go back and renew, I mean to go and apply for fresh grants, we shall entertain the applications for renewal. The applications for renewal are going to be so many. Let me tell you, Edison, there are not many people who have divided the estates of the deceased. The grants, we have grants as old as 20 years. People go to grants and they sat on them. And you know why? I have seen many people and I have had so many people. When somebody dies, the family says, no, we don't want to divide the land of the deceased. We don't want to divide the estate of the deceased. Actually, last week I was interacting with Anid. He said, no, how do we divide our father's land? How do we divide our father's estate? And it is titled to the land. It is registered land. So people have that still. A deceased died, but they don't want to touch his estate. And they think maybe they are praising the deceased, and they are by praising the deceased, they are praising the beneficiaries. They don't want to touch the property. Like when my father died, people said, no, we shouldn't distribute the estate. But I said, the owner has died. So what happens to his estate? Distribute it. They distributed. So other people started to sell their shares. They said, you man, they are selling your father's land. No, I said, no, it is not my father's land. My father died. It is his land. and my father is lucky that the land has been sold by his son. So what's wrong with that one? So you cannot own the property forever and ever. Even the properties we are owning, they were owned by other people. So that's how the world is. The world must, I mean, life has to continue. You cannot hold on the property for forever and ever. No. And the framers of this law, they are very right. Somebody dies, distribute his property within 1 year and file an account in court. Then any person who has got his share, he can deal with it in any way he wants. Why do you want to hold on the property for years and years? Somebody died, he cannot own the property. He cannot go with the property to heaven or to hell. So distribute it, and then the beneficiaries get their share. Life. Actually, I have seen people suffering. The person died and left chunks of land, but they say, we cannot sell our father's land. Now somebody can sell a portion and get capital and start his life. But they say, no, this is our father's land. But your father died a long time ago. What do you want to do with the land? So those are the problems. Now, because of that, people still have grants as old as 30 years. Even the administrators, they are granted the debtors and they die before distributing the estates. You find in many cases the administrators even died. And even the beneficiaries have never even attempted to get the other debtors, the other administrators. So administrators are granted debtors. They also die. And the estate is there. So that's what the problem is.
The government which passed the law has also been going around encouraging people not to divide,
you see,
the estate or the land, and I think would it be correct to say that there is a conceptual problem in the law, that for some people asking that the law assumes you must divide the estate, but someone is saying that Madhvani is an estate. Madhvani died in 1920.
Yes. Yes.
The estate has remained undistributed, and that is its growth. It has grown, while as opposed to being divided. Does the law require us to divide and not to grow the asset base? I think that's.
But you cannot compare Madhvani, a capitalist, like with the peasant in Intungamo. how do you do that? It is not comparable. How do you do that? And actually, what I have been telling my clients, those ones who don't want to distribute the properties to provide, I have been giving them very good advice. What you do, if land is registered, you make sure that it moves from the names of the administrator to all your names. You are registered, so that your name is there.
Joint owners.
You can use it jointly because it is in your names. But it is not proper, and it is illegal for the land to remain in the name of the deceased or the administrator. So for the administrator to wind the estate and to show that he has finished, then he will show that he has given the land to all the beneficiaries and even has registered it into the names of the beneficiaries. He will have finished his work. Then if your name appears on the title, it means you have a share. You have a share. Maybe you can own it as tenants in common. So that after a beneficiary has died, then his sons and daughters can take his share. But also that poses a danger, because I had a client. Their father died, and they were about 6. So they said, no, we cannot divide our father's land. Okay. So they said we shall use it communally. But some were rich, others were poor. Those who are rich, they brought cows now. Very many cows. And they were grazing there. But other people didn't have any cows. They didn't have even a goat. So this is your land, you have a share. But somebody is grazing his cows there. But you don't have anything to graze. So what happens? Now they started grumbling. Now they said, no, these people are cheating us. These people now are using land, and for us we are not benefiting. Can you give us our share? They ended up in court now, because the other people didn't want to divide. These ones who didn't have cows, they said no. Now in that case, give us our shares. They ended up in court, and court said divide the land, and they divided, and each one took a share. And those ones even sold their shares. But the other ones who are grazing, they are still grazing on their shares. So you see, it is very hard to own land community, especially in this country. The beneficiaries don't agree. In most cases, they start fighting. You have seen. So how do you own land community? And I have seen even some people, they come to make wills, and they make will, and they make a company, and make all the beneficiaries shareholders. So, and the beneficiaries. After that, a war will break out. Who will become a director of the company? Who will become a financial director? Yes. So now you see, the deceased has his own program on earth. You cannot impose it on the beneficiaries. If he had a farm, how sure is he that I also am interested in the farm?
Farming.
No, I might be interested in real property. I'm not interested in farming. Yes. So how do you give me a farm, and then you make it a company that I have to run the company as a farm? And me, I'm practicing law here in Kampala, and you want me to go and manage a farm in Ntungamo. See, that communal land is very hard. It is very hard to manage. So that's why when somebody dies, the property of that person should be distributed. If some beneficiaries have money, then they can buy out to the other ones. Yes.
Yeah. Mr. Norbert, are you able to speak now? You could ask your question before you ask other questions. Mr. Norbert, are you able to speak? Sorry, I think he's unable to speak. So yeah, I have 2 questions. I will gain them. The first one is, if I apply for to renew the as administration and my application is dismissed, do I appeal, or what do I do if the application is dismissed? Then another one is, we only have 3 judges at the family division of the High Court, and considering that there are very many people who are applying for renewal, so all those who are litigating as administrators or executors, are they supposed to apply to different divisions of the High Court from wherever they are litigating from, or they're supposed to go back to family division of the High Court to apply from there?
What? I don't understand.
The question is,
yes,
we only have 3 judges at family division.
Yes.
But I got mine as admission from family division of the High Court, but now I'm litigating for maybe civil division using those letters. So now they are going to expire. So am I supposed to apply for renewal? Do I first of all go back to family division, or I can apply from the same court where I am litigating from as of now? because you are looking at a point where court is having very many applications as of now. We have 3 judges, and almost just imagine the whole Kampala and Kampala is applying to that same court, and they already have their backlog. So if I'm not getting in another court, can I apply to that court, or I need also to go back to family division? Thank you.
So the question is, you have applied for a grant.
Yes.
And your application is dismissed. In most cases, what I have seen, like in my application where my client was given an extension of 2 weeks, they give you a reason
For dismissal.
of dismissal.
So you rectify.
They give you a reason of dismissal. Then you rectify that reason. And you see now court also, you see court is court, and there is this requirement, and which court must put into account. And I don't think if this requirement is put into account, they will plenary dismiss your application. Is it in the interest of the beneficiaries? If court has ascertained that one, then it cannot dismiss your application. Because you administer the estate for the beneficiaries. So if it is in the interest of the beneficiaries, then court cannot refuse. Maybe court has refused it. It has seen a danger against the beneficiaries. And also in the reasons of dismissal, there always, in the ruling, there is always reasons. And they tell you even what to do. So you can apply afresh. You can apply for, you can bring another application. Like I have told you, I have brought another application. The other one it was given 2 weeks, but they have expired. Now I have applied again for extension. So when your application is dismissed, depending on the reasons, you can bring about to another application. Then somebody says that can you make a renewal, an application for renewal, like in a civil court?
Yes.
That is not possible because you make an application for renewal from the court which issued the grant. Because that is where the file of the administration cause is. Actually, before considering the renewal, court must first see that original file of the ASC, called the administration cause, because that's where all the important information is. That's where the important information from Administrator General is. Also, on that file, that's where in the petition, all the beneficiaries are. So now, how do you bring now an application for extension like in a civil court? It is not allowed. That one cannot happen. So you have to go to the court, which issued the grant. Yes.
If you're just joining us, we are with Mr. Maxim Mutabingwa. We are taking questions on the upcoming expiry of letters of administration and grant of probate. As you may or may not know, the lifespan of many of the grants of probate expire within 2 days. They expire on Saturday. So if you have a letter of administration, you should look at it and guard it jealously, because on Friday it is likely to have expired. Alfred, I think you had a question.
Yes, I had a question. This one was asking. This one doesn't want to find himself in the fracas of applying for letters of administration. So he's asking, what are the different modes of estate planning that I can do to avoid the necessity of applying for letters of administration at one time?
So maybe you can apply early before you die. Maybe I think that's what he's talking about.
I think
before you die, yeah, that one you can plan.
Let me rephrase the question.
He can distribute before he dies.
Okay, but the proper question could be, like, if he dies, he doesn't want his children to undergo through this whole hassle.
Yes.
Of applying for probate, before they manage his estate.
Yes.
So what can he do so that his children avoid that hassle?
Yeah, a person can manage his estate even after he has died. Yeah, you can manage your estate when you are dead, and you can only do that when you have made a will. When you have died tested, you make a will, and you provide for everything how you want your property to be managed, and you put it in a document called the will, and your will speaks after your death.
No, but
yes,
but Mr.
You make a will. Or alternatively, there is another alternative. you distribute your properties before you die. And that one is what you call gift inter vivos. You give all your properties, each one gets a share. I have seen very many people, they do that before they die. You see, death comes just abruptly, it does not warn. You cannot first have a meeting that you see now, I'm going to die, let me give you this, let me give you, no, it does not warn. So, I have seen some people, especially elderly people, they distribute most of their properties, and they remain with the few properties. You understand? So that when he dies, all that fracas is not there. Each one knows his property, and you know when you give property before you die, that one cannot be included in the letters of administration because it belongs to that person whom you have given it. We call it gift inter vivos. Or you make a will. You make a will. Once you have made a will, actually, you see in this country we have a very bad culture. People think that if you make a will, that you are going to die. No, a will is a very good thing. Like my father wrote a will before he died. He went to a lawyer and then he left a will. So some days after burial, then they brought us a will. Everything he had wanted, we did. And we have never had any quarrel in our family. He was a rich peasant in Ntungamo. We divided our land according to the will. Actually, for us, we didn't even run to courts. No, the will is there. He has given you your part. He has given you your share. Everybody takes his share. He died in 2002, and nobody has even ever fought another person because of that will. But we were a big family. If that will was not there, I don't know what would have happened to us. You see, you can manage your properties before you die by making a will or by distributing the properties before you die. Those are the only two ways. Maybe another, you might forget this question also, because it is in the questions you had given to me. Disposal of the properties of the what? Of the deceased. Listeners out there, you must understand this. There is a danger in buying the properties of the deceased. Actually, there are people who have bought properties of the deceased, even they have not transferred them into their names. And now, this Amendment Act has come up with a very tough law now, a very tough provision. And that one now, because Edison, you may forget it, and it is very, very important, because people should know this. What do you have to do to buy property of the estate of the deceased? Section 267 of the Succession Act, Cap 268 states, you hear, subject to Section 23 and 30, subsection 2, an executor, executrix, or administrator or administratrix, as may be applicable, may, with the written consent of the spouse and all the lineal descendants of the deceased person, dispose of the property of the deceased, either wholly or in part. Have you heard? So, if you want to buy the property of the deceased, and they have made this section subject to Section 23. Section 23 of the Succession Act is about the percentages, about the division of the properties of the intestate. How much percentage does each take? So it is subject to that. So you need written consent of the surviving spouse. Actually, now as we talk, the administrators who are selling the properties of the deceased, even without the knowledge of of the spouses, they don't know the law. Now the spouse has to consent. Not only the spouse, but all the lineal descendants of the deceased. Lineal descendants. Who are lineal descendants of the deceased? When you go to the definition section, lineal descendants means a person who is descended in a direct line from the deceased, and includes a child, a grandchild of the deceased, and any other person related to the deceased in a direct descending line up to 6 degrees descending. You hear? So you need consent of all these people. So by then now, it is going to be practically impossible to buy the property of the deceased. It is going to be very, very, very hard. Very, very hard. How do you buy the property of the deceased under such a law? Actually, business is going to come to a standstill. You want to buy the property of the deceased, some beneficiaries are not residing in this county. Or some beneficiaries, they veto your what? Your idea. They say, no. For us, we are not interested in selling. Or they put conditions. You will not, and they don't give their consent. So how will you sell the property? You cannot. So listeners out there, if you are buying the property of the deceased, you have to be very careful. This section is very, very tough. Section 267 of the Succession Act, disposal of the property. You need consent of the spouse, you need consent of the linear descendants. And it is not a consent, but it is a written consent. It must be in writing, not oral.
It will be very difficult
And
to buy.
Section 267, subsection 8 states that, you hear this now, any disposal of the property belonging to the estate of the deceased person in contravention of this act shall be void. Have you heard, listeners? If you don't follow this section, anything you do with the property of the deceased, then it is void. And as we talk now, even today, even tomorrow, people now, they think that it is still business as usual. The administrators have been going to the lawyers or where, then they make agreements without even the beneficiaries' knowledge. But you can see how the law has changed now. If the property belongs to the deceased, you have to follow the law. If you don't follow the law, then whatever you have done is null and void.
Then
I don't want you to forget this section. It is very, very important for the listeners. Yes.
Just now, in addition to that same question, if I bought property from the citizens following that law, the section as you mentioned, 267, but we have not yet finished the transferring, like maybe some money is pending to be paid, we have not completed the transaction, but probably the person who was saying had the mindset of defrauding me of my money. So he refuses now to apply for renewal of the grant, or apply for a fresh grant, but I bought from the state. So as me, as a buyer, what remedy do I have?
As a buyer, you have, if you bought, did you buy before the coming into force of this act?
I bought during the coming force into that the act.
Before or
actually,
after?
Just imagine I bought last week.
Yes, last week. Okay.
And I have not finished the transaction.
Yes,
but
yes.
that's are going to expire on 31st.
Yes, yes.
So, and then the person who sold to me maybe just wants to
He doesn't want
defraud
to renew.
Yeah, exactly.
Your interest.
Exactly.
So
what
you see,
should I do?
that is one of the problems now which the citizens are going to face.
Yes.
Somebody has taken your money, but has not registered the land into your names, has not given you your property.
Yes.
And then now his grant has expired.
Yes.
Yeah, the man now will go to church and pray and start celebrating. He will celebrate. Because you cannot force him now to, you cannot compare him now to do what you had wanted. He may be even be reluctant. So the only remedy you have is to sue him in court. With agreement, because you made an agreement with him.
Yes.
So you go to court and sue him, and then maybe you get a court order. You understand? So if the administrator has neglected to do his work, then you sue him. We have many suits against administrators. Then court can compel him. But all of you, counsel, you know the process of getting a judgment from court. The backlog, how long it takes. It is very cumbersome. Yes.
Okay. Thank you. I think for anyone who's joining us, we are with Mr. Maxim Mutabingwa discussing all things administration. You've just heard, if you buy property from the estate of a deceased person without getting the consent of the beneficiaries, you are likely to be in a dead deal. Your deal may not succeed. And the law is also nullifying. So it seems the new Succession Amendment Act seems to, I think the mischief that it seems to cure is it seems to protect beneficiaries. I think previously the assumption must have been that administrators were very powerful, and I think it's now seeking to curtail them, to make the grants time-bound, the work clear, the distributions clear, and any dealing in estate property must be done with the consent of beneficiaries. That is the or ultimate driving force. Would you agree with Mr. Mutabinga that's the ultimate driving theory that the legislature was working with, making sure that it reduces the power of the administrator and moves further and further to protect the beneficiary? Of course, some of the dangers, for example, what happens to mortgaged property? If an administrator walks into the bank to mortgage property, does he go against the spirit and letter of those particular sections? I think section 267 that you've read.
Now under this law, the administrator cannot mortgage the estate property without the consent of the beneficiaries. If there are 20 beneficiaries, all of you have to talk to the bank, and they have to sign all the consents or the documents to mortgage the estate property. So that's why now business is, as I said, it is not business as usual.
Yes.
It is not business as usual. Now this property of the deceased, actually, by the way I see it, guys, the way I see it, actually, there are not many people who are going now to take this month of becoming administrators. People are going to decline.
Yes.
Because the obligations, the obligations are very tough. They are very tough. And even the law even creates some offenses against them. I don't think many people now will be willing to apply for it as administration.
Okay.
It seems the draftsman was in a dispute.
Yes.
A property dispute. At the time that...
there must have been a problem. Because the responsibility which is put on the administrators now is too heavy. It is too heavy.
Then just before we leave banks, so with banks, imagine I go as administration and I've been administering a set of receipts. He has a bank account. So that bank account which I've been administering, now letters have expired. What is its fate when I'm renewing? That time lag when I'm renewing. And that account maybe has been receiving money or pension, you get, and I've been getting money from that account. I've been actually using the same letters. So what's my fate as I wait to renew? How can I keep on being the one that's using the account, accessing the money? Then vis-a-vis for the banks now, it's about their customers to comply, to tell them to keep applying for renewal so that they can still manage the debts of the deceased. So those are two duties now on the customer and the bank. How can the banks play around that?
Because now, okay, start with the banks now.
Okay, let me start with the banks.
The banks now, I don't think now practically it's going to be possible to manage the asset, the land belonging to the asset of the deceased, property belonging to the asset of the deceased. How now? Because you are supposed to divide it in 1 year and file an inventory and an account.
Let me start with the bank to make it bigger. You see, I have the deceased was receiving maybe pension and it's deposited on a bank account. So I was this administrator of the estate and I'd taken those letters, so I was managing that account. So I keep getting money from that account. Now the letters have expired, but now they keep sending in that money. So this time, like between applying for renewal, by the time courts are burdened, by the time they would run the renewal, so how can I probably access my money or the money of the estate without now proper letters?
Yes. This amendment, there is a section which I have not read, but it is there. It caters for that situation of the pensions.
Yes.
There is a specific section, but which I cannot get readily.
Okay.
So people should not fear because that one is provided by the amendment.
Okay.
There is a solution in this law. They shouldn't get worried. I could get it quickly.
Yeah, you could get it for you, just because even now the banks need to advise their customers and they really don't know what could be done.
5.
As we're getting the section
55. 55.4.
as we're getting the
Because I have seen
section,
it. 55.4.
Now you can unmute.
55, 2, 3, 4. Subsection 2 and 3 shall not apply to letters of administration granted under section 212 or person's pension forming part of the state. So pension is, I had seen this section. This is a new law. We have not. So section 255, subsection 4. Subsection 2. Subsection 2 is about the grant of property, and section 1 shall be valid for a period not exceeding 2 years, but the pension is saved. And subsection 4, B, persons forming a pension forming part of the estate is exonerated. Yes, is exempted.
And I say,
Yes. Then
I see Mr. Chairman, you are saying 256.
256. 256. 4. So, what is 4? Subsection 2 and 3 shall not apply to letters of administration granted to A. Letters of administration granted under section 2 and 2. B. The portion of the estate administered under section 23.2. 23.2 is about 23.2 is 23.2. Notwithstanding subsection 20% of this shall not be distributed but shall be held in trust for the education, maintenance, and welfare. So it doesn't apply to this estate, which is not distributed but is for the education, maintenance, and welfare of the following categories of lineal descendants until they cease to qualify as such: a minor child of the intestate, and where he or she attains 18 years of age, until he or she ceases to qualify under paragraph B. So you can see these ones are exempted. Then 256, 4C, pension forming part of the estate. So pension is exempted. So people, administrators who are receiving pension, they are catered for under the law, and they shouldn't get worried.
Okay, so thank you for everybody who has joined us. We are now reaching 8:30. So we've done 1.5 hours on this very important subject. As you can see, the framers of the law decided to protect the beneficiaries. And I think the law was written realizing that a lot of people who administer estates have been very unfair to a lot of people on whose behalf they are administering. That being said, the law still has its challenges. I think that's my takeaway from this conversation. The administrative challenges is a burden imposed on the courts that are already overburdened. Last week, if I can just digress to our normal programming, I think it was last week or the week before. Last week, there was a commercial justice conference where His Lordship, the Honorable, the Chief Justice, said that Uganda needs 20,000 judges to dispose of the cases that we have now, and 50,000 magistrates. He was saying that before the biting effect of the succession amendment law. he was saying that without taking into account the kind of problem we are dealing with. And actually, we shall come to address that, I think, in later discussions. But I heard very clearly the Honorable, the Chief Justice, saying that we need 20,000 judges. He also was kind enough to tell us how many of the 20,000 we actually have. He said currently we have less than 100. So we have a deficit of 19,900 judges before the coming into force of the Succession Amendment Act. Today, I saw the High Court in Mukono issue a cause list for criminal cases. That they were deciding to try people who have been on remand, and they decided to resolve it. And the first case was a 2015 case. A decade. A Ugandan has been waiting 1 decade to be tried. I don't know if the witnesses against him can remember what happened, or if their memory can survive a forensic cross-examination if they ask serious questions. So I don't know if those witnesses and those victims of that crime may get justice. I don't know if that person himself may get justice. And I think there were about 20 cases on that cause list, and all of them were between 7 to 10 years. 5 to 10 years waiting. So here we are. introduce, so while this law is intending to protect or that with one hand, does it also take away from these beneficiaries with another? Is a question that remains to be answered, and we shall see in how the judiciary approaches this issue, especially seeing that the 100 ladies and gentlemen who serve in our judiciary are carrying, according to His Lordship, the Chief Justice, the burden of 19,900 people. That being said, it's time for us to close this space. And before we do, as we traditionally do, we will ask Mr. Mutabingwa for his closing remarks on this subject and any other subject. But also, before you do close, just allow me on behalf of everybody here to thank you for giving the last 2 weeks to this conversation and to really bringing this subject into the bedrooms, the sitting rooms, the cars, the dining tables of many families up and down the country who are now listening, to lawyers and to non-lawyers alike, who are listening, who are understanding their challenges and who are making decisions that are relevant to them. So thank you. Allow me to thank you on behalf of all of our listeners and also viewers. And maybe we can hand over to you, Mr. Mutabingwa, for your closing remarks. So maybe just also before you close, before we actually hand over to you, maybe let me also thank Alfred Muyaka and also invite him, maybe if he can give us a closing remark, and then we hand over to Mr. Mutabingwa.
Well, just wish to thank Mr. Mutabingwa for joining us for 2 weeks. And after last week, I think he had to go and make more research now on the question which were left behind. And even today he has been answering that. So we thank you for your time. Ordinarily, people will be paying for this advice, but you have done enough pro bono. And I'm sure people may even come to you. This one is from Muntungam to do for them more pro bono. So thank you so much for your time. And yeah, for everyone who has been on the space, even for the 2 occasions, last week and this week, and for those who have always joined us, thank you for giving us your evening, your Wednesday evenings. Even when you call you on short notes, you always come on board and you have the conversation engaging. Thank you. That's from me and the team. You can have the parting shots from Mr. Mutabingwa after 2 weeks of the dead are not dying.
Thank you very much, gentlemen, for inviting me. You see, I was a teacher. I taught at LDC for 8 years. So I like teaching, and especially when people get information, when they get knowledge, I become happy. I always tell people that, you see, in this legal practice of ours, we shouldn't run after money, but we should run after service and to run after justice. So whenever justice is done, me, I feel so happy. And you know, I have been fighting for justice. So where there is a war for justice, I'm the first one on the front line. So when I feel that the citizens have learned an important topic like this, when the citizens have learned the law and they have known their rights, I feel so happy. So what I'm telling the citizens over there who are listening, especially non-lawyers, you people, you should know what it takes, what it requires to get letters of administration, so that you are not cheated always. Because administrators and beneficiaries have been cheated by people who know the law. Something which costs a very small amount of money, you end up giving out almost all the estate to the detriment of the beneficiaries. So you know what it takes to get that grant of letters of administration, so that when you are negotiating, then you have knowledge, you have information, so that you are not cheated, so that you are not fleeced. So you can approach a lawyer. Now in this country, there are so many lawyers. I think advocates now, we are going to 7,000. Yeah, you can approach a lawyer, or even now, every sub-county, there is a court. You can go to court if you are in the village. You can go to court and ask, instead of being cheated. Then another category I would wish to warn are the people who are buying the properties of the estate of the deceased. As you have heard from the law, it is now very, very tough to buy the property of the deceased, because it requires all the beneficiaries, the consent of all the beneficiaries. It requires the consent of the spouse
and the lineal descendants.
So the administrator should divide the estate very quickly. So buy from somebody who has got his share, and he must be having all the documents And I think if we follow the law, these disputes of estates, they are going to reduce in court if this law is strictly followed. But what I can see also, this law is very complicated also. It might be very hard to follow. And the way I see it, Edison and the team,
Yes.
I see this law going back to Parliament for amendment, for some relaxation. Because some parts are not going to be practical. For example, somebody was asking me, and they had asked me this question last week. Now I have letters of administration. I'm in court. The grant expires.
Yes.
Do I still have a right to be a party to a suit?
Yes.
Like that one? It's still debatable.
Yes.
Because my work as an administrator has ended. Or you apply for renew, they don't renew even. And then an administrator now applies and he's granted.
So do I add that? But
So now is he going to be added to the suit? So those issues now are coming.
Yes.
So the way I see this law going back to Parliament for panel beating, so that it becomes practical. Otherwise, listeners, I thank you very much for listening to me, and God bless you. Thank you very much.
Thank you so much, Mr. Maxim Mutabingwa, for taking your time to come and join us in this conversation and for really discussing with us. For all those who are joining us, and from wherever you have joined us from, we are truly honored and privileged to have you here. We are honored and privileged that you've taken time off your evening to join us. And it's been a great conversation, in my view, a fantastic discussion, bringing light into this issue of estates, probate, letters of administration, and matters that concern many families up and down this country. And we hope that the information that you've got from this space, you'll find it useful in your families and in your legal practices up and down the country. Of course, here at this space, we are very, very committed to, I know Mr. Mutabingwa last week said that sometimes when when we're looking at recruitment of judges, we may end up removing a thug from the bar and putting him on the bench. But that notwithstanding, for many of us at least, we are holding fast to the view that the constitution of this country needs to be respected. And one of the issues which has come out very clearly from this discussion is we are likely to see an increment of cases in our courts. We have 3 judges in the family division of the High Court in Kampala who are going to sit on so many applications. We have judges in the circuits up and down this country some of them already are burdened with 1,000, 2,000 cases. They're just going to have their dockets double easily in the next few weeks and months as families go around trying to bring themselves into compliance with this law. We have heard from the Honorable the Chief Justice himself, who has told us that the state of the business of the courts of judicature so requires, because he has 100 people and he needs 20,000. If he hired every lawyer, according to him, and made every lawyer a high court judge, there would still be backlog. This is according to the Honorable the Chief Justice. And so there is absolutely no reason why we cannot now come to the realization that we need to invoke the provisions of the Constitution that allow for, at least in cases like this, where we have emergency attacks on the courts, at least to call on the bar, to call on those who are qualified to rise to the occasion as mission-based judges to sit and determine some of these matters, because the business of the court so requires. And that has been said by no less than the Honorable, the Chief Justice himself. Otherwise, for those of you who have joined us from wherever you've joined us from, whichever part of the world or the country you've joined us from, thank you for joining us. We are blessed, we are privileged, we are honored to have you. We're honored to have you, and it's been a great and insightful discussion, as Sheila Ankunda says. Thank you, Sheila. Thank you, everybody who is joining us. Thank you for all the comments we are seeing. And if you're joining us from wherever you're joining us from, as we always say, good morning, good afternoon, good evening, and good night. And to those of you who are members of the Uganda Law Society, and even those who are not, it would only be good if you went to bed listening to a very good song that speaks about our election, which will soon come, and also speaks about me. None other than Olimujawa Musaja Singa.